Good morning, everybody. Welcome to the 2026 Annual Nonprofit Conference. It's great to see everyone here in our new venue, which I'm very pleased about. And thanks to the staff for finding this space for us, and welcome to folks online. My name is Joe Kakish. I am General Counsel at Growth Energy and the co-chair of the ACC NCR Nonprofit and Associations Committee. And we're going to start off on our first session. I'll be your host for this session and also a moderator. This session is, as you see, Nonprofits Under Pressure, Updates in Year 2 of the Trump administration, sponsored by Venable. So let me just do a few housekeeping items before we get into the session. If you're joining via Zoom, you can submit your questions using the chat box, and they'll share them with the panelists during the course of the day. We have limited time, so we may not be able to get all of the questions. If you're here in the room and we ran out of time, you'll have the chance to ask questions during the break as well. And also, I think if you're going to ask questions in the room, it'd be helpful if you use the mic that we'll pass around so that folks online can hear your questions as well. And if you are online, you don't get your questions answered, you can follow up with the panelists directly. They should have contact information for each of them. Please note that today's session and each sessions are run for about 60 minutes, and they're being recorded. You should have received the slides for the sessions in yesterday's reminder email, and I know I did. Those in the room, you can also access them through a QR code on the agenda, at the back of the agenda. And sorry, my notes. And then for those online, we'll put a copy in the chat for you guys to download as well. So this session is obviously technology enabled because we're doing it hybrid. So appreciate everyone's patience with any glitches that may occur, but I think we're going to have a smooth day. But if you're online and you have an issue, I've been told to say that it's found best to log off and log back in. So that's usually good advice in life. So we'll apply it here. And if you dialed in by today's program by phone, please note that you will not receive CLE credit. And to comply with Virginia MCLE rules, you must be logged in with your name and company. Before we begin, please take a moment to silence your cell phones and any other alerts on all of your devices. And as a reminder, all remarks made by these panelists are their own opinions and do not constitute legal advice or necessarily reflect the viewpoints of their company, their firm, ACC NCR, or ACC Global. So now, with all that, it's my pleasure to introduce you to our panel for today's presentation. So let me move to another set of notes. Maybe we start with, so I'm going to first introduce you to Janice Ryan. She's partner and co-chair of the Nonprofit Organizations Practice Group at Venable here in DC, where she specializes in nonprofit corporate law, tax exemption, and political law compliance. She provides strategic counsel to charities, trade associations, and advocacy groups on navigating complex regulatory environments and evaluating funding arrangements. Her extensive experience includes helping mission-driven entities manage risk and adapt to evolving federal oversight to successfully achieve their public policy goals. And I said, I'm Joe Kakish, I'm the moderator here. I can read what I wrote about myself quickly. I'm the General Counsel and Secretary of Growth Energy, which is a nonprofit. It's a renewable fuels trade association, and where I oversee all legal, regulatory, and corporate compliance affairs. I specialize in administrative law and regulatory programs, drawing on experience navigating federal agency priorities and compliance mandates. I'll leave it with that. So why don't we go ahead and get started? Janice, here we are again. I think last year we did an initial check-in with the first few months of the Trump administration. We're 18 months in, and there's a lot going on. And today's focus is to really home in on the most significant, regulatory and federal legal developments in the sector and where things stand. So before we get into the specifics, let me start, where do you see, big picture, sort of the biggest legal or regulatory shifts affecting this sector?
Yeah, hi Joe. Thanks for that introduction, and it's really nice to be with you all today. There is so much that we could talk about. We have, 60 minutes, so we really did try to focus on some of the major areas that we're seeing in terms of changes that affect the nonprofit sector in the Trump administration. I think that in trying to distill where we are today, I think it's really a matter of watching sort of a government-wide rollout of new rules, new interpretations of existing statutes, and new enforcement priorities coming out of the federal government. Um, Targeting activities, which frankly are generally lawful, but that this administration disfavors in terms of their social policy priorities. It might be related to immigration or diversity, equity, and inclusion, uh, civic participation. And I think the thing that's really interesting is a lot of the language that we see around these issues is couched in illegality or criminality. And I think, the bottom line is that the statutes governing some of these areas really haven't changed. And it's still very much a challenge for the sector to understand what is it now that is illegal, and how does that impact what we do and the decisions that we make about our programs and our activities. So we're still trying to glean from executive orders and agency guidance or memos out of the Department of Justice what their views are in terms of what is now illegal and what they are going to prioritize from an enforcement perspective, and how do we apply that, and also watching these things through many in the sector become subject of litigation, so challenging these things in court, and seeing these issues work their way through the court system, and sometimes with great success for the plaintiffs, a lot around procedure. So we still, I think, in some cases don't have a sense in terms from the courts of what where some of these positions stand on the merits. But nevertheless, there's a lot of active litigation in the area. So we're definitely, well into the administration continuing to advance its social priorities through all of the arms of the federal government. And there's still a lot of uncertainty.
Well, let's dig into that uncertainty and start with an area that I know is front of mind for a lot of folks in here, which relates to funding and grants, federal grants. And there's a number of proposed changes over the past year, but let's start with the proposed changes to the uniform grants regulation and why we should be sort of paying attention.
Yeah, absolutely. And Joe, just to apologize, my clicker wasn't working, so I was going to try to advance the slides for.
Okay.
Yeah, so I'll move those through. But just to give you all a sense of where we're going today, we're going to talk about federal funding issues. That's kind of the first bucket. We'll talk about issues affecting tax exempt organizations through the IRS and other issues, and then some law enforcement priorities and directives. So that's kind of the general overview of the discussion that we hope to have today. So yeah, Joe, I think that from the very first, days of the Trump administration last year, we saw that there were dramatic changes in the way the federal government was going to approach federal grants and federal funding in general, and that meant rescission of funds, taking those funds away, trying to cancel grants, and changes in the way that the government was seeking groups to certify compliance with executive orders. All of that happened over the course of last year. And now I think what we're seeing, which is fairly significant, is that the Office of Management and Budget has proposed a rulemaking that would essentially kind of formalize in a regulation what we've seen the administration carry out in the federal funding space over the last year or so, and this is a pretty significant rulemaking. OMB proposed the rule the very end of May. There was a comment period through July 13th, so comments have closed, and the agency received, oh, thank you, almost 500,000 comments. They want to have the rule in effect by October 1 of this year. And those who are involved in agency rulemaking, that just it's preposterous. Now, I don't know, but that doesn't mean they won't. How they managed to address 500,000 comments in August, in September, I don't really know. But nevertheless, that is their stated goal. And I think the thing to understand about this rule is that, in addition to kind of codifying, I guess I would say, in a way, through the rulemaking process, the Trump administration's executive orders and policy priorities related to federal funding, it shifts what is currently guidance that the Office of Management and Budget puts out for all agencies, that the agencies then adopt as rules separately, into an actual regulation that would be binding on federal fund recipients. So the agencies could still supplement this rule through agency-specific rules. This would be much more aligned with how the federal procurement rules are structured, the FAR, the Federal Acquisition Regulation.
I was just going to ask quickly about that. Different agencies manage their priorities differently with respect to guidance or FAQs or regulations, notice and comment rulemaking. Here, to have a rulemaking in place, does that provide a greater level of certainty and security, no matter what the substance is? Is that a better place for organizations in general? Like, I deal with Treasury regulations or Treasury guidances that are, or proposed rules that are never finalized, right? And so you never really know.
Yeah.
The department has a lot of flexibility to change at any moment. But here, when you have a notice and comment rulemaking, is there an upside to that, putting the content aside?
My understanding is that effectively the agencies adopt the uniform guidance that OMB creates almost verbatim. So I think as a practical matter, I don't know that it will have a huge shift coming from guidance to a rule. But nevertheless, it's entirely questionable whether OMB has this authority. And so, even assuming that they get through the 500,000 comments, they adopt a final rule, this is almost certainly going to be subject to litigation, that people will challenge this, for a variety of reasons. One of which is, does OMB even have the authority to make rules in this space? So that's really what this does. So it takes existing guidance around, the federal government's administration of federal funds in contracts. It's not contracts; it's grants, that would now be a rule that would be binding. All right, we're gonna try to hold the microphone and advance the slides and double check my notes. So I just wanted to say, I've already sort of given you an overview of what these proposed updates seem largely designed to do. In addition to kind of codifying the administration's guidance around federal funding and advancing their social priorities, I think one aspect of this that's interesting is that I think it really is focused on enhancing executive authority as opposed to congressional authority in the federal funding space. So I think that that's an interesting element to look at as well. We're going to talk about maybe 5 or 6 key elements of the uniform guidance rule. But I do want you to know that we have a lot of information available. My colleagues in Venable's government grants and contracts practice have done a full hour-long webinar on this topic alone, and we don't have time for that. So I've included a link to the webinar. They also have a great client alert with lots of additional detail on the uniform guidance. And so I do encourage you to look at that if you want more information on this topic. So with that, let's go into some of the key elements here. So, one of the proposals that would be new involves adding elements for the federal government when they evaluate potential awardees. So, this is kind of a risk assessment that they would make for your organization. Is it a good idea for them to give a grant to you? One of the things that they will now be under this proposed rule uh, considering would be whether your organization has any history of questionable practices. Examples are plagiarism, discredited studies, unlawful discrimination, or activities inconsistent with religious liberty laws. Another element that they would be considering would be your organization's membership in or affiliation with organizations engage in activities that violate federal law, undermine public safety or national security, or advocate for the overthrow of the US government. Um, and you might, this is kind of like, we want to know who your friends are, right? And what are they doing that we don't like? And these terms are very broad and subjective, right? So what is it that this means to undermine public safety? What does that mean? Does that mean I can't get a federal award because someone I'm affiliated with? And what does it mean to be affiliated with someone else? These things are really kind of challenging to understand. And, I think almost certainly this is another area where we would expect litigation because of the First Amendment concerns that this raises as well. Another provision of the proposed rule involves making a review of an agency award decision before actually making the award. And what it would do is require a new involvement by senior political appointees at the White House to review a federal award before it's made. And those senior appointees would be directed to consider before awarding federal funds or a grant, that is, that the awards must demonstrably advance the president's policy priorities, and they cannot fund, promote, or facilitate racial preferences, denial of the sex binary in humans, or the notion that sex is a chosen or mutable characteristic. They cannot fund, promote, or facilitate, again, illegal immigration or initiatives that compromise public safety or promote anti-American values.
I mean, that's a lot to digest, but putting aside even the merits of those sort of conditions, this establishment of the pre-issuance review mechanism, is there any sense about how many folks that's going to take, or what does it extend the review period because they need time to incorporate these new standards, I guess, into review? Is there any sort of consideration about that, or any thoughts in the proposed rule? Because I know there's usually some sort of, what is the impact on the budget and the government staffing and so forth? Is that play? I don't know. It just seems like it's a lot of additional bureaucracy.
I think that's probably right in terms of the administration of this, but I don't know. We'll see how it plays out. I do believe this is happening now, right? So
Yeah.
this is a bit of a codification of, I think, what we've seen over the past year. So in addition to determining in advance whether you might be eligible for an award, and then having political folks review before a grant is awarded, there are also new prohibitions on what grant funds can be used for. And so the new rule would explicitly prohibit use of federal funds to promote, encourage, subsidize, or facilitate DEI principles or practices that violate any applicable federal anti-discrimination laws. We see that language through executive orders and guidance and all sorts of, over and over again. We still don't know, what that means in practice. We know, what is illegal based on case law and, current law. But, this administration, I think, has different views of that. You cannot use federal funds to promote gender ideology or gender affirming care for minors. So, the preamble states that it specifically states it anticipates some commenters may contend that the unlawful DEI provision is excessively vague or open to misinterpretation. So, I mean, it's sort of teeing it up, right? Like, what does this mean? And it's certainly going to be subject to challenge. But the agency points to the Department of Justice's July 2025 memorandum on what they view as illegal DEI, the U.S. Supreme Court's decision in Students for Fair Admissions versus Harvard, and a December opinion from the DOJ's Office of Legal Counsel on this topic.
Given that acknowledgement, do you expect significant, whenever the rule comes out, October 1st or otherwise, do you expect significant revisions or clarifications to come out in the final rule from what was in the proposed text?
I mean, in the normal rulemaking process, all of these kinds of things have already been submitted in the comment period, and so they would have to address that in some manner, but whether they actually change anything, I don't know. Certainly if they were going to try to move this through and publish a final rule in October, which again, I just don't know how the rule would stand up in court at this point, because I don't know how they would have adequately had time to grapple with the comments. So the new rule also talks about and again codifies what we've been seeing over the last year, provisions for the federal government to terminate grants for convenience and to suspend grants, which was not, frankly, typically part of termination for convenience, was not typically part of federal grant agreements. Agencies could put that in to your grant if they wanted to. It was discretionary, but it wasn't common. So this would now require agencies to include in the grant a unilateral right for the agency to terminate when the agency determines that it's in the interest of the federal agency, including if the award no longer effectuates program goals, agency priorities, or the national interest at the time of termination. So, I mean, this just brings back into the play the uncertainty that comes with accepting federal funds. If as an organization that's trying to help people, they're running programs. The idea here would be like, okay, well, we've got a grant, but can we keep the grant? Are they going to take it away? Why? And do we have any control over that? It just really adds to the uncertainty of dealing with the federal government and relying on federal funding. There would be no administrative appeal rights for these discretionary terminations, and the agency would also have authority to terminate subrecipients that the agency determines pose reputational risk to the federal agency.
So for no administrative appeal, that means you go straight to judicial review? You have to bring a lawsuit in the district court to challenge?
Yeah. Suspension, this would sort of be like a stop work order in a contract that the federal government, under FAR has the ability to say, please stop. And while we're in this stop work period, you have to ensure that you are, not incurring new costs, that you're limiting the amount of costs that are being incurred during this period, but that you will be reimbursed for costs that have to be incurred to comply with the stop work order. Here, there is no clear right to compensation for costs of this suspension. It just says that the agency should consider and seek to resolve any budgetary or schedule impacts resulting from the stop work, and as appropriate and warranted under the circumstances, the agency should consider making adjustments to the project schedule, budget, or both. So, more uncertainty. When would the new guidance apply only to new grants? This is a question. Or is there any expectation of retroactivity? your existing awards will continue to be in effect. I don't know exactly when the effective date of the rule would be. I'd have to go back and check, assuming that they did publish a final rule.
I had assumed it would be October 1st because that's the budget year
Yeah,
that would be effective upon publication, but who knows?
yeah. So there's just a couple more provisions that I wanted to touch on. One is that there are new requirements that reports that grantees are required to make to agency officer of inspectors general under existing law. So this is something you have to do. You have to report to the OIG credible evidence of fraud and bribery related violations of federal law, including the False Claims Act. You have to make reports to the Office Inspector General of those kinds of potential violations. What the new rule would say is that the OIG must send those disclosures to the U.S. Attorney's Office for the District of Columbia within 10 days of receipt. So it takes away any discretion for OIG to evaluate a claim that it receives or a report or notice that it receives from a grantee of potential violations and evaluate whether it is a good, report that requires more, investigation. It really just says, okay, no matter what, OIG has to tell the U.S. attorney. And so, bringing DOJ into place into that process from the very beginning, potentially has affects who's going to report and what. And that it really heightens the risk associated with making some of these kinds of reports, because I think by and large, groups want to be forthcoming, they want to comply with the law, they want to provide these notices to OIG. But if you have heightened risk of, potentially having DOJ involved from the very beginning, you may be more thoughtful about, does this rise to the level of something that needs to be reported to OIG or not? So this is an interesting dynamic as well. There are a couple provisions related to foreign entities. This one that I wanted to focus on is that there would now be a prohibition on using federal funds to support a bilateral or multilateral collaboration, agreement, program, or activities with a covered foreign country or covered foreign entity. And it would apply to both direct and indirect funds. A covered foreign country is defined as a foreign adversary, a country of particular concern, or a country subject to sanctions or restrictions relating to national security. Think of like China or North Korea, or these are the types of countries that we're talking about. A covered entity is defined as an entity owned or controlled by or acting on behalf of a covered foreign country, an entity identified as an entity of particular concern under certain federal agency authorities, or an entity affiliated with the military, intelligence, or security services of a covered foreign country. This could be a significant change in terms of your ability to use federal funds in connection with, foreign universities, for example, or other kinds of partners that you may have to, carry out your programs.
Thanks for that overview, Janice. So let's move over from the uniform guidance to the system for award management. And I understand that GSA is proposing some changes to certifications into the SAM. Could you speak to that?
Yeah, so the system for award management is the registration database that the government uses, that current and potential awardees you have to have an account in SAM in order to receive federal funds. And the SAM system already requires grantees to certify compliance with all applicable requirements of all other federal laws, executive orders, regulations, and public policies, including Title VI of the Civil Rights Act of 1964. This is something that you have to agree. We comply with this when you sign up for SAM. the GSA has proposed a rule that would update the certifications that you have to make on SAM, again, to incorporate the administration's, views on illegal DEI, for example. It would add that you must certify compliance with Title VII of the Civil Rights Act, which does apply to most employers in the United States, but there are exceptions for, very small organizations with few employees. So it's not necessarily applicable to all recipients. Um, and it provides a list of practices that may violate these laws, including cultural competence requirements, overcoming obstacles narratives or diversity statements, race based training sessions, implicit segregation through program eligibility, race based diverse slate policies and hiring, race based selection for contracts. And it also includes new certifications on knowing interactions with an illegal alien, funding, subsidizing, or facilitating violence, terrorism, or other illegal activities that threaten public safety or national security. So, again, we're seeing this language. There's lots of broad, ill-defined or undefined terms. And what the government is asking is that when you sign up as a threshold matter, just to be able to apply for an award, that you're going to certify under penalty of False Claims Act, or penalties potentially, that you comply with all of these interpretations of the law that this administration is putting out. So that, again, comment period is closed. GSA has received almost 22,000 comments. Whether this, again, ever gets through the actual agency rulemaking process, I don't really know, but that's another significant rule to keep in mind.
I assume that will also be subject to litigation as soon as they finalize it as well.
Yeah, and these, again, I think these are actually almost all of these things are being litigated in other cases and other fronts based on the stuff that we saw last year.
I was going to ask about that because you said in particular the uniform guidance is codifying existing practice, so there must already be a significant litigation landscape currently that this guidance will formalize in a single place.
Yeah, grant recipients were asked very early on last year in the administration to make these certifications on a one-on-one basis between the agency and the grant recipients. That this would just put this into place in terms of the rule, that this would now be part of SAM. They wouldn't ask you to do it when you sign a particular award or agree to, accept funds. It would actually be, part of this sort of system-wide registration process.
Well, that's a lot to absorb, and thank you for the detail on the slides. So close us out here on this funding section. Where does this leave us in 2026 and to the remainder of the administration?
Yeah, this is sort of, I think we've kind of gone over all of this already, but essentially they're saying federal funds can't be used for the kinds of programs and activities that the administration disfavors in terms of DEI or immigration, these kinds of things will be potentially, subject to False Claims Act liability, which is very significant. And we're still left with a lot of questions, like which DEI initiatives are illegal, what constitutes promoting DEI or gender ideology. How do we reconcile this with state law requirements, right? So if you engage in federal, you have state funding, for example, they may have rules, or even just as a matter of employment, for example, they may have rules that you behave in a certain way that entirely conflict with what the federal requirements are here. And so that is something that is evolving and that we still, don't know a lot about in terms of how that will work. And so all of this means, frankly, a lot of litigation. And so, we just kind of have to keep our eyes open and see how these things play out.
Well, let's turn to the IRS and some other developments here. You have a slide up on IRS determinations. I know there was, at least in the beginning of the Trump administration last year, a lot of news about folks losing their status because of the policy for preference of the administration. So why don't you kind of run us through where we are with the IRS and these tax exempt determinations?
Yeah, I do think that what I was hearing from folks in the sector last year was, oh, I'm worried about my tax exempt status being revoked. And the reality is that nothing has really changed in determinations and examinations. It really hasn't, by and large. You know, um, I think the other thing to consider, which is important always with the IRS and the exempt organizations function, is their resource limitations. And it's been reported that the workforce of the IRS has been reduced agency wide by 27% and 30% in TEGE. And I think that probably means we're maybe like 500 employees in exempt orgs, although it's hard to know exactly. Um, and what we've been hearing is that EO division staff have been moved from examinations, so conducting audits of existing organizations, to determinations in order to process the incoming applications that are regularly received. That is actually probably consistent with what we are seeing, at least on our side, when we are getting determination letters now. Sometimes it's like they're being turned around in a week, which frankly, I mean, I don't know how many of you have to frequently apply for tax exempt status for new organizations, but there have been times when you have to wait like 6 months, 8 months, even longer in order to get a determination letter. So I mean, it does strike me that probably makes sense, that's where they're shifting the resources in order to process new applications more quickly. And I just think it's helpful to sort of level set on this, which is that like it's typical for the IRS to process like 2,500 to 3,500 examinations in a given year. And
So that number hasn't changed
not
historically?
No, I mean that seems to be pretty consistent, at least over like I don't know, the last like decade maybe. And revocations are pretty rare. They're often in the low dozens, sometimes 100. I think maybe 2023 fiscal year it was like 140, which seemed to be pretty high, but nevertheless, that's kind of the typical cadence of what we see in terms of the IRS evaluating exempt organizations.
Well, let's turn to their sort of IRS priorities in this fiscal year, and I'll preview the next couple of slides. One is the sort of IRS priorities, and then focusing specifically on potential changes for C3s going forward.
Yeah, so the IRS issues a priority guidance plan across the IRS. For 2025, 2026, there's a handful of issues that they've identified that affect the tax exempt sector. I've not listed all of them, but I have put a few here that I think folks may be interested in understanding that the IRS says these are priorities, right? There's one bucket of 501c3 issues. There's a bucket under the heading deregulation and burden reduction. Again, this is actually the heading that they use in the priority guidance plan. And then there's some under the heading of the One Big Beautiful Bill Act implementation. On Section 501c3, and those are kind of the ones that I wanted to focus on today, although, I mean, we could talk about all these others at length, but they have identified that they want to provide guidance on application of the fundamental public policy against racial discrimination in determining eligibility of private schools for recognition of tax exempt status under 501c3. So that's one area that they've identified as a priority affecting C3s. The other is to provide guidance on the statutory prohibition in 501c3 against participation or intervention in political campaigns.
So I want to focus on that briefly. Does the guidance plan forecast what the guidance will look like?
It does
It
not.
does not. Okay.
No, it's literally just bullets. Basically that. But I think that these are interesting because we're going to talk in a moment about proposed rulemakings. I want to touch briefly on the Johnson Amendment one because we're not going to talk about this afterward. But I think this is relevant to something many of you may have followed, although maybe not. There is a case in Texas called the National Religious Broadcasters case that involved a couple of churches that challenged the Johnson Amendment. They sued the IRS to say that the prohibition against supporting or opposing candidates violated their First Amendment rights, and that they wanted to be able to essentially, from the pulpit, tell their congregants how to vote or talk about candidates. And the DOJ, acting on behalf of IRS and the plaintiffs in that case, proposed a settlement where the IRS said it was they would not enforce the Johnson Amendment against these churches for pulpit politicking, essentially. And the judge in the NRB case ultimately decided he did not have jurisdiction to approve this settlement under the Tax Anti-Injunction Act. Basically, they said this proposal from the IRS and that this was being challenged is effectively restraining collection of a tax. And so that is on appeal. The idea here is that the churches could sue after the IRS actually says they have to pay the tax. And so we'll see where that goes. But I do suspect that this priority guidance plan bullet relates somewhat, at least, to churches being able to support or oppose candidates in their communications with their congregants.
I just want to note about that case and some of the other ambiguities in the guidance is this first question. The First Amendment really is kind of peppered throughout all this on multiple directions.
Yeah.
Right. That the administration is advancing a certain perspective, perhaps in violation of the First Amendment, or suppressing expression on the other side. So I mean, my sense is that you're going to see a lot of these First Amendment challenges coming from all sides of the political spectrum with respect to a lot of the work that the administration is doing in a variety of areas. I don't know if you guys have thought about the sort of constitutional.
Absolutely. I mean, I think that that's one of the, as lawyers for tax exempt organizations, I'm also a campaign finance lawyer. Everything we do in this civil sector is, has protections under the First Amendment. Who we associate with, our viewpoints, what we advocate for. I think that the very regulation of this sector involves these dicey questions about the First Amendment and what the Constitution allows. And so, this is playing in very hot waters, I guess I would say, from a constitutional litigation standpoint. So I think it's very fascinating and certainly something that will, continue to play out in the courts, I think. So there are two potential rulemakings that we've been alerted to. The one is related to that priority guidance plan, the bullet one, which is that OMB has announced an intent to issue a notice of proposed rulemaking. So again, we don't even have an actual proposed rule yet on application of the fundamental public policy against racial discrimination in schools. The notice of intent to issue said that it would amend the Treasury regulation to clarify a specific one, 1.501c3 1d2, to clarify that certain schools that discriminate on the basis of race are not operated exclusively for charitable purposes. So that's all we know. But
we've had this in the Biden administration as well, where the administration will announce a notice of an intent to announce a notice of a proposed rule. So what am I supposed to do with that?
Right.
Right. And, the administration, in a different context, the Biden administration did it really at the tail end of the administration. It was kind of like a way to hand it off.
Yeah.
It served more of an optics, I
Uh,
think, purpose
yeah.
than sort of really setting a structured pathway toward rulemaking. I don't know if what your thought is, but every time I see those sort of very prefatory types of notices, I often wonder what the point of them are.
I agree.
Okay.
I mean, again, will they do it? Maybe.
Yeah.
Maybe they will never do it.
Yeah.
And the rulemaking process takes time, right? So, it's 2026. We don't even have a notice of proposed rulemaking. When will they get to it? Will they get to it? I don't know. But this is something that they have identified as something they intend to do. The other announcement that we received was that in a press release Treasury issued, that they want to propose regulations to revise the Form 990. And specifically, they have said that these revisions would be intended to improve transparency, strengthen tax administration, and provide clearer reporting on certain activities of 501c3 organizations, including on government grants, government contracts, and fiscal sponsorship arrangements. Again, we don't really know if they will ever do this. We don't know what they would want to require, how it would look. We have no real defined term for fiscal sponsorship arrangement. So how are they going to define that? What do you have to do? We don't really know. But it does, it's something that is out there that we have to consider in this year. I just kind of wanted to touch base on the concepts of illegality and violation of fundamental public policy in the tax exemption context, because it plays into what we're seeing, again, as I mentioned at the outset, the terminology that this administration is using with respect to the civil sector, and not just nonprofits, but this concept of things being illegal or criminal, because we see it pop up in another place, which is the Public Service Loan Forgiveness Program rules, which I'm going to talk about in a moment. But the basic concept here is that an organization can't qualify for tax exempt status if it has an illegal purpose or engages in substantial illegal activities. The fundamental public policy doctrine is sort of a spin on that the Supreme Court in the Bob Jones University case explained that the purpose of a charity can't be illegal or violate established public policy. The court didn't say exactly what fundamental public policy is, but in looking at the facts of that particular case, which involved a policy that Bob Jones University had against interracial students believing in or being involved in interracial dating or interracial marriage. The court looked to actions of all three branches of the federal government over 3 decades to conclude that it was a fundamental public policy that racial discrimination in education is essentially illegal, that it violates public policy. So these concepts we're seeing, again, in this proposed rulemaking that they want to, engage in. They've referenced the Bob Jones University concept. In the Public Service Loan Forgiveness Program rulemaking, they actually kind of tried to pull this doctrine into the program, which was designed. And first, let me just say, the Department of Education's rule was supposed to go into effect on July 1 of this year, and the rule was struck down by federal courts, 2 different federal courts in Massachusetts and DC, before it went into effect. So this rule is not, it's vacated. But what it would have done is it would have allowed the Secretary of Education to determine that certain 501c3 employers were not eligible employers for the Public Service Loan Forgiveness Program. So if you were a student who wanted to get your loans repaid through this program, the Department of Education could say, no, your service with this employer doesn't count because we've determined that they have an illegal purpose, a substantial illegal purpose. And those illegal purposes would have included aiding or abetting violations of federal immigration laws, supporting terrorism, Again, gender affirming care for minors, engaging in a pattern of aiding and abetting illegal discrimination, engaging in a pattern of violating state tort laws, including against trespassing, disorderly conduct, public nuisance, vandalism, or obstruction of highways. We have these vague concepts again, and it would be entirely within the discretion of the Secretary of Education to determine you, 501c3, or you have substantial illegal purposes and therefore you cannot participate in this program. Huge issue for recruiting and retaining talent for 501c3s, hospitals, universities, all of the kinds of organizations that you would expect who would want to be participating in this program to have their employees benefit from it.
In light of that vagueness, what was the basis of the court striking it down? Was it because it was impermissibly vague, or?
Yeah, the courts took different. The two courts took slightly different tacks, but essentially the agency exceeded its statutory authority. So the statute defined what a qualified employer was and did not provide the Department of Education with discretion to further qualify it. And then there were First Amendment concerns about vagueness and protection of viewpoint. So that's an example of organizations successfully challenging some of these, proposals, and I'm sure we'll see more of that. Let's see, we're getting close to the end here. Legislation.
Yes, tell us about your exciting day on the Hill with respect to these.
Yeah, this is hard because I think sometimes there's lots of interesting bills that get introduced, many of which will probably never see the light of day. And there's various bills that sort of percolate. Again, it may just be for the press hit, right? Like, how do we know? What I don't have on this slide, because late breaking news, the House Ways and Means Committee yesterday marked up 4 different bills affecting nonprofit organizations. One of which is listed here, the Fiscal Sponsorship Transparency Act of 2026. That's HR 9721. These all got reported out of committee. There was a very lively hearing. If you're ever interested, you can go on the House Ways and Means Committee website. You can listen to the hearing. I still don't think that these are likely to be passed. Okay, but I think it's interesting to see what's being discussed on the Hill. So the 4 bills relate to 2 of them relate to foreign funding of nonprofits. One of them is related to fiscal sponsorship, and then one of them is related to religious beliefs, and it comes back to this illegality public policy doctrine concept.
Do you know if any of the bills had bipartisan co-sponsors, or is it mostly
No,
Republican?
They're party line. They were adopted with just Republican approval on the committee. One of them is called Stopping or Foreign Funding Transparency Act. That's HR 9772. And I can provide information to you all, but it's on the House Ways and Means Committee website if you're interested. That would require any 501c organization. It amends the 6033B, which is the provision of the Internal Revenue Code that it feeds into the Form 990. It would require any 501c organization to report the aggregate amount of foreign donors on the Form 990, and the aggregate amount of donors grouped by foreign countries of concern. It says that the organization can rely on donor representation, that they are from a particular country, unless they have other reason to believe that is not reliable. And it would define the foreign donors that would be reported would align with the definition of a foreign national under the Federal Election Campaign Act, so FECA. So you would now have a new obligation to track whether your donors are from foreign countries, and you would have to report in the aggregate those donors. The other one is called Stopping Foreign Influence in Elections Act. This would restrict organizations from making contributions to 501c4s or to federal political committees, which by and large would just be a federal super PAC because corporations are prohibited from making contributions to political committees. So you as a 501c could not make a contribution to a C4 or a federal super PAC if in the prior 2 years you have received any money from a foreign national. And so again, this is kind of peculiar, but essentially it would probably prohibit 501c3s from making contributions to an affiliated C4, even if the C4 does no political activity, if the C3 has any foreign national money at all. So again, this is a new significant thing. I can't read that, Janine.
We have 5 minutes.
Okay. There's lots of other interesting things, but why don't we talk about the law enforcement?
Yes, let's move to that. So yeah, go ahead, focus on the EEOC piece. I was going to introduce it, but the slide is already.
Yeah, the DEI questions that we've talked about with federal funding and other kinds of policy angles here have been interesting. But fundamentally, the Equal Employment Opportunity Commission has been very active in enforcing Title VII in particular, not just outside of the federal funding space, but the employment discrimination laws on what you might have called reverse discrimination kinds of claims. They're very active in this space, and we're seeing. I've listed a number of enforcement matters here on this slide. There are links to the EEOC press releases of settlements that for-profit and nonprofit companies are paying in trying to resolve these kinds of investigations from the EEOC. So, making sure that you're really buttoned up on your Title VII compliance and you're understanding sort of, what is and is not illegal, just under existing law, and making sure that you are, focused on that, I think is still really important in year 2. And the last thing I want to talk about is sort of a law enforcement directive from the White House, a series of executive orders and directives focus on what's called domestic terrorism or organized political violence. In September, the president issued an executive order designating Antifa as a domestic terrorist organization. Following that, there is a National Security Presidential Memorandum, NSPM 7, that instructs the FBI and the Joint Terrorism Task Forces across the country to essentially investigate what they call domestic terrorism. Domestic terrorism isn't itself a federal crime. There is a definition of domestic terrorism in federal statute, but domestic terrorism is not a crime. But the directives identify domestic terrorism with reference to ideology or viewpoint, including anti-Americanism, anti-capitalism, and anti-Christianity, extremism on migration, race, and gender, hostility towards those who hold traditional American values on family, religion, and morality. And really, it's instructing our federal law enforcement apparatus to look for potential violations of criminal law, federal criminal law, in focusing on these kinds of viewpoints.
So just to clarify, you have to find that sort of underlying established criminal predicate.
Yes.
And then the domestic terrorism, because it's not itself a crime, is what? Is it an add-on? Is it like, you know what I mean? Like,
it's a label.
It's a label that for a pre-existing criminal violation.
It's a label.
Okay.
And I think what's important to know is that this is directing, they talk about this in terms of conspiracy, and they want to identify what they consider funders of people and organizers of people who have engaged in crimes.
But it's not like an enhancement. Like
no,
there's a hate crime enhancement, or, based on viewpoint. That's not what this is.
No. But they want to target investigations and inquiries into funders, employees of organizations, and there is this element of instructing the IRS to ensure that no tax-exempt entities are directly or indirectly financing political violence or domestic terrorism. Which leads me to the last point, which is We've heard, at least in the Wall Street Journal, that the administration wants to use IRS Criminal Investigation Division to pursue criminal inquiries of left-leaning groups and their donors. This article references the National Security Presidential Memorandum 7. And, you know, IRSCI is very different from the examinations and determinations in the civil side that I talked about before, where nothing is really changed. You know, this is one of these things where if you think the FBI is coming or that you're being surveilled or you're hearing from others that they're asking questions about you, it's important to, get white collar criminal counsel involved and tax attorneys, because these are things that are much more significant. Whether we see it, I don't know, but I think that some of the national security presidential memorandum elements, I think we have seen already. The Southern Poverty Law Center indictment. There is an indictment involving protesters at a church in Minneapolis coming out of the ICE
Don Lemon.
surge. The Don Lemon, yeah. They are using these kinds of I think elements that you're seeing play out. And with that,
On that happy note,
yeah,
we'll stop there. I think Janice gave us a lot to think about. There's a lot going on, and I really appreciate your comprehensive presentation today. And on behalf of the chapter and on the nonprofit network, we thank you and Venable for the session. Thank you.
thank you, Joe. Thank you, everyone.